Jai Hind everyone. Today we are going to discuss chapter 17 of IPC about offences against property. Chapter 17 of offences against property find an important place in IPC, and this is the second longest chapter consisting of 85 sections from section 378 to 462. And the basic element of all the offences under this chapter is dishonesty. The term dishonesty is defined under section 24, which describes as the intention of causing wrongful gain to one person and wrongful loss to another. So today we are going to understand the concept of theft. As per the section 378, theft is whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent moves that property in order to such taking is said to commit theft. So, from the definition it is clear that to constitute theft the following ingredients are required. So, the first ingredient is dishonest intention. The accused must have a dishonest intention to take the property. The taking will not amount to theft unless the intention with which it is taken is dishonest. So, there can be no theft where there is no dishonesty. For example, A in good faith believing property belonging to B to be his own property, and he takes that property out of the B's possession. Here, as A does not take dishonestly, as such he does not commit theft. But if there is dishonest intention of A to take that property with him, then it can be considered as theft under section 378. Second ingredient is movable property. As we have read earlier, the property must be movable. Third ingredient, property should be taken away. Now you have taken the movable property which was in the possession of another without consent, and it can be either permanent or it can be temporary also. And this question was raised in case of Pyarelal Bhargav versus State. Here what happened, a government employee took office file and gave it to someone for the purpose of 2 days, and after their usage he kept it back. Now whether this can be considered as theft? It was held in this case that permanent movement of movable property is not required, even done for temporary period is considered as theft. So, the gist of this ingredient can be said that the property must be taken out of the possession of another person, resulting in wrongful gain by one and wrongful loss to another. Lifting money from the road can't be considered as theft. Acha, there is one more case law which is coming in alignment in Pyarelal Bhargav case, that is K.N. Mehra versus State of Rajasthan. Here in this case, an accused took Indian Air Force plane without authority for temporary purpose. Though he has taken plane for temporary purpose without authorization, so it can be considered as theft. The fourth ingredient is without consent. The taking must be without that person's consent. Even the temporary retention is enough to show that the offence has been committed. The fifth ingredient, the property must be moved in order to taking. As human body can be moved from one place to another, but it can't be subject matter to theft. But there are some exception, that is mummies or dead bodies preserved in laboratory and medical college can't be considered as can be considered as the subject matter of theft. However, if somebody is stealing kidney or any other organ apart from the body, then it can be considered as theft. That is a technical aspect. When all of these are happening, only then we can say that theft has been committed. So, as defined under section 378, theft is the dishonest removal of movable property out of possession of any person without his consent. It is thus an offence against possession and not against ownership, as stated in illustration J and K to section 378. The offence of theft consists in dishonest taking of any movable property out of the possession of another without his consent. Now coming towards the punishment of theft, which is mentioned under section 379, it says that whoever commits theft shall be punished with imprisonment of either description for a term which may extend to 3 years or fine or with both. So, basically this section prescribe punishment for theft which may extend to your period of 3 years or fine or both. The offence under this section is cognizable plus non-bailable and triable by a magistrate. Now, coming towards the section 380, that is theft in dwelling house, etc. So, whoever commits theft in any building, tent or vessel, which building, tent or vessel is used as human dwelling or used for the custody of property, shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also liable to fine. The object of this section is to give greater security only to property deposited in a house and not to the immovable property of the person or the property from whom it is stolen. Theft from a person in dwelling house is only a simple theft under section 379. Now, coming towards the ingredient. So, the first ingredient is the subject matter of theft is movable property. Second, it was in possession of a person. Third, the accused moved it dishonestly. Accused did it so without the consent of the person. The accused did so intending to take it out of the person's possession. But the foremost ingredient is the property stolen was from building, tent or vessel used as dwelling house or for the custody of the property. The offence under this section is cognizable, non-bailable, non-compoundable and triable by magistrate. Now, coming towards the section 381, that is theft by clerk or servant or property in possession of master. Whoever being a clerk or servant or being employed in the capacity of clerk or servant commit theft in respect of any property in the possession of his master or employer, he shall be punished with imprisonment of either description for a term which may extend to 7 years and shall also liable to fine. The position of the master or employer need not be actual physical position. Even a constructive position is sufficient for the purpose of this section. A clerk or servant basically is a person bound either by an express or implied contract of service to obey the orders and submit to the control of his master in the transaction of the business which it is his duty to perform as such clerk or servant. An unpaid apprentice is a clerk or servant within the meaning of this section. Now, what does section 382 says? It says theft after preparation made for causing death, hurt or restraint in order to committing of the theft. So, basically suppose Mr. X going to A's home for theft with loaded gun with this preparation that if A wakes up, he may kill or hurt him, or if he going to stop him, he will hurt Mr. A. So, whoever commits theft having made preparation for causing death or hurt or restraint or fear of death, hurt, restraint to any person in order to committing of such theft or in order to effecting of his escape after the committing of such theft or in order to the retaining of the property taken by such theft shall be punished with rigorous imprisonment for a term which may extend to 10 years and shall also liable to fine. The only difference between the offence under this section and that in the case of robbery is that some injury is actually inflicted in the case of robbery, while under this section all preparation made for effecting his escape after committing such theft or to retain the property stolen is sufficient.